Welcome back, everyone, to Think About It, the podcast from Forward HR Consulting.
Good to be here.
Today, we're diving into something pretty significant for anyone in HR, a recent Supreme Court of India judgment. It came down on May 14th, 2025.
That's right. It involves Vijaya Bank and a former employee, Mr. Prashant B. Narnaware.
And the whole thing really centers around a specific clause in his appointment letter. It raises big questions, about employee mobility versus what employers need.
Exactly. The core issue is, well, can a company legally make an employee pay a fixed sum, liquidated damages, if they resign before finishing a minimum service period?
In this case, it was 3 years, right? And she was asked to pay up.
Correct. So what we want to do today is unpack the arguments, look at how the Supreme Court decided, and really think about what this means for you listening, for how you structure your own HR policies and employment agreements.
Okay, so let's set the scene. How did this whole dispute actually begin? Mr. Narnaware wasn't exactly a stranger to Vijaya Bank, was he?
No, not at all. The judgment mentions he first joined way back in 1999, started as a probationary assistant manager.
Got confirmed in 2001, even got promoted later on. So he had history there.
Definitely. But then in 2006, the bank advertised some new officer positions. One was senior manager cost accountant.
Oh, okay.
And that job advert had this specific clause, 9W, which basically said if you get selected, you have to sign an indemnity bond for 2 lakh rupees.
Payable if you leave before 3 years.
Exactly. Minimum 3 years service.
And Mr. Narnaware saw this, applied for the senior manager job, and he got it.
He did. And his appointment letter, which was dated August 7th, 2007, it included this condition again, now as Clause 11K. Same deal. 3 years minimum service, 2 lakh rupees if you resign early.
And he signed it. And crucially, he actually resigned from his previous job at Vijaya Bank to take this new senior manager role, knowing these terms.
Yes, that's a key detail. It was an internal move, but under near specific conditions he agreed to in September 2007.
So fast forward a bit. He's in the senior manager role.
But then in July 2009, so well before the 3 years were up, he resigns again, this time to go to IDBI Bank.
Okay. And Vijaya Bank accepted the resignation.
They did. And he paid the 2 lakh rupees in October 2009. But, and this is important, he paid it under protest.
Signaling he wasn't happy about it.
Precisely. It laid the groundwork for him to challenge the legality of those clauses, 9W and 11K. He filed a writ petition with the High Court.
Which is basically asking the court to review if the clauses were fair and legal.
You got it.
And initially, the High Court actually found in his favor.
It did, yes. They quashed Clause 11K, told the bank to refund the money. It looks like they leaned heavily on a previous High Court decision, the KY Venkatesh Kumar versus BEMA limited case.
Okay, so they saw a precedent there.
They did. But this is where the story takes a turn when it gets to the Supreme Court.
Right. The Supreme Court then had to look at it fresh. What was the main question they framed?
They really focused on 2 core legal principles. First, did Clause 11K act as a restraint of trade under Section 27 of the Indian Contract Act? Or, second, was it opposed to public policy under Section 23 of that act, maybe even violating his constitutional rights?
So, big fundamental questions about contracts and fairness. Let's take the restraint of trade part first.
I guess.
What was the thinking there? They looked at some older cases, right?
They did. They referenced landmark rulings like Niranjan Shankar Golakari versus Century Spinning and Manufacturing, and also Superintendent's Company versus Krishan Murgai.
And those cases help distinguish between different kinds of restrictions.
Exactly. They highlight a really important difference for us in HR restrictions during employment versus restrictions after employment ends.
Okay.
Generally, if a clause just says you have to work exclusively for your employer while you're employed, that's usually not seen as a restraint of trade.
Unless it's completely unreasonable or, excessively harsh.
Right. That's the caveat. But in this case, the Supreme Court looked at Clause 11K and said, well, its main purpose seems to be ensuring a minimum period of service for this specific role.
Not stopping him from working elsewhere after leaving Vijaya Bank.
Precisely. They saw it as part of the employment agreement itself, aiming for some stability, not a restriction on his future career. So they concluded it didn't violate Section 27.
Okay, that makes sense. But then there's the public policy argument under Section 23. That sounds a bit more flexible, maybe.
It is, and that's where the arguments got quite nuanced. Mr. Narnaware argued, look, the bank had all the power here. It was a standard contract, take it or leave it. He felt the clause was unfair, too burdensome, and just let the bank get money it didn't really earn.
Unequal bargaining power. That's a common argument.
Yes, and he cited a principle from another case, Central Inland Water Transport Corporation versus Brojanath Ganguly, which basically says that if a contract is really one-sided because one party has way more power, it can be void because it's against public policy.
So the court had to weigh that against. Well, what is public policy today?
Exactly. And the court acknowledged that public policy isn't set in stone. They pointed out, referencing the Golakari case again, that you also have to consider if the restriction is reasonable for protecting the employer's interests.
And they brought in the economic context too, didn't they?
Yeah.
The changes in India since the 90s.
They did. They noted that India's economy has liberalized. Public sector banks like Vijaya Bank are now competing heavily, needing to be efficient and, crucially, keep skilled staff.
So high turnover is a real problem for them.
A big problem. The court suggested that maybe requiring a minimum service period could be seen as a reasonable tool for banks like this to reduce that turnover, avoid constant recruitment costs, and improve overall efficiency.
Which, in a competitive environment, could actually serve the public interest.
That was the reasoning. It shows how public policy can be interpreted through the lens of current economic needs.
Okay, what about the amount, the 2 lakh rupees? Did the court think that figure was reasonable?
Well, they looked at the bank side of it. Vijaya Bank argued that losing senior people like Mr. Narnaware prematurely isn't trivial. It causes genuine financial loss, creates a lot of administrative work.
Running recruitment processes again and again, which costs time and money, especially for public sector bodies that have strict rules to follow.
Exactly. They have constitutional mandates like Articles 14 and 16 to ensure fair opportunity. The court basically felt the bank's position wasn't unjust or unreasonable here.
Especially considering his senior role.
Yes, and his likely compensation package. The court felt the 2 lakh amount wasn't so huge that it actually made it impossible for him to resign. I mean, the proof is he did resign and paid it.
Right, it wasn't an absolute barrier.
It seems not.
Right, and this is how they distinguished it from that Bemel case the High Court relied on.
Precisely. The Supreme Court pointed out a couple of key differences. One, the Bemel case apparently involved not just a minimum service term, but also some kind of restriction on where the employee could work after leaving BEM.
Ah, so a post-employment restriction too.
That's what the Supreme Court suggested. And second, the Bemel judgment didn't seem to consider the specific financial hit a public sector company takes when skilled people leave early.
So the context was different.
Very different. And it's a good reminder for all of us. You can't just apply rulings blanketly. You have to look at the specific facts of this case. What applied to Bemel didn't automatically fit Vijaya Bank.
Okay, so weighing all that up, the nature of the clause, the economic context, the amount, the distinction from what was the final verdict from the Supreme Court?
They allowed Vijaya Bank's appeal. They set aside the High Court's judgment that was in favor of Mr. Narnaware.
So the bank got to keep the 2 lakh rupees.
Essentially, yes. The Supreme Court concluded that in this specific situation, Clause 11K wasn't an unlawful restraint of trade, nor was it against public policy.
And they mentioned another similar case was dismissed too.
Yeah, Civil Appeal Number 11499 of 2016 involved the same clause, apparently, and the court dismissed it based on this Vijaya Bank judgment. So it shows some consistency in their thinking on this point.
Okay, so let's bring this back to us, to the HR professionals listening. What are the big takeaways here? It feels like the court is acknowledging that businesses, especially public sector ones needing stability, have legitimate reasons for these kinds of clauses.
I think that's right. It really underlines the need for organizations to think carefully about why they're putting in minimum service periods or liquidated damages.
You need a clear rationale.
Absolutely.
Yeah.
If you can actually demonstrate the real costs, financial, administrative, associated with high turnover and important roles, that seems to strengthen your case if the clause is ever challenged.
So it suggests that these clauses can be enforceable provided they're, reasonably drafted. Right. They shouldn't be trying to lock someone in forever or stop them working anywhere else.
Right. And the amount of damages needs to be justifiable, not punitive. It's about recouping reasonable costs related to the early departure, not just penalizing the employee.
It really does highlight that constant balancing act we face in HR, doesn't it? Between an employee's freedom to move and the organization's need for some level of stability and return on investment.
It does. And it also shows, as we discussed, that legal interpretations, especially around something like public policy, aren't fixed. They evolve with the economic and social landscape.
Definitely food for thought for anyone involved in drafting or reviewing employment contracts. It's crucial to stay updated on how courts are viewing these issues.
Couldn't agree more.
We really encourage you to consider how these principles might play out in your own workplaces. And of course, for more insights and guidance on HR best practices and employment law developments, do check out our website.
That's www.forwardhrconsulting.com.
Thanks for tuning in to Think About It.
We'll talk to you next time.